In a normal situation, the party giving the rights receives value through the transaction. A right is a remedy. If the party who gave the right is later accused of not performing, the right he gave as security when he received the value can be used to seize the property to satisfy the terms of the agreement. In subsection B, a pre-existing claim makes an appearance. The United States already promised to repay the international leaders, but if it doesn't pay, the international leaders can use United States statutes to collect from U.S. citizens. Both parties give value and both receive rights in each transaction. The value given can be absolutely anything that is sufficient to support a simple contract or parole contract in the jurisdiction where the agreement is made. The rights given can be anything to secure the obligation incorporated in the agreement, including defenses against claims made by the parties against each other. Public to public. B. A person, creditor, equals a corporation, gives value, use of credit, mortgage, for rights to foreclose and defense if he, creditor, acquires the rights to foreclose and defense as security for satisfaction payment of pre-existing claim, national debt. The debtor's promise to return credit is a second promise. The first promise is a pledge to not question the national debt. The national debt, ladies and gentlemen, can never be questioned or challenged. B. A person, debtor, equals U.S. citizen, gives value, promise, for rights, use of credit and defense, if he, U.S. citizen, acquires the rights, use of credits and defense as security for satisfaction, extension of credit of a pre-existing claim, beneficial interest in the trust created by the Constitution. The approval of credit application is a second promise. The first promise is the constitutional oath the president took. Public to public. Person, corporation, gives value, use of credit, for rights to foreclose and defense as security for national debt. U.S. citizen, a person, U.S. citizen, gives value, promise, for rights, use of credit and defense as security for beneficial interest. Private to public. B. A person, creditor, U.S. citizen, which is your Social Security entity and estate and trust, gives value, man's signature on an application, you're the agent giving the signature, for rights to use public credit if he, the U.S. citizen, again, we're doing everything on behalf of our estate, our trust, our juristic person here. We're acting as the power of attorney and the agent for said citizen, U.S. citizenship, that Social Security account and the estate that was manifested at your birth, acquires the rights to use public credit as security for satisfaction, distribution from the trust of a pre-existing claim, man's beneficial interest in the trust. B. A person, debtor, equals a corporation, gives value, use of public credit, for rights, defense, if he, corporation, acquires the rights, defense, as security for satisfaction, trust distribution of a pre-existing claim, man's beneficial interest in the trust. Private to public. Person, U.S. citizen, gives value, man's signature, for rights, use of public credit, as security for distribution from the trust. Person, corporation, whether it be unincorporated or a incorporated corporation, gives value, use of public credit, for rights, defense, as security for beneficial interest in trust. The following interpretation deal with creditors of the United States and the United States, backed by U.S. citizens as sureties for the United States for the national debt. B, a person, debtor equals corporate United States, gives value, new reorganization plan to pay, for rights, defense against foreclosure, as security, promise not to foreclose now, for satisfaction, partial performance of a pre-existing claim, international bankers' right to foreclose on the United States. This is exactly why when they're going through a foreclosure on a property, they're actually not doing it correctly, and they can be barred from their claim because they brought a claim for which relief cannot be granted, because the bankers, when they're going to foreclose, are not notifying all the real parties in interest. And what I mean by that is the United States is a party of interest, and they should be named as a defendant in a foreclosure action, because the United States is in a superior position of first in time, first in line, lien holder on all assets and property within the United States. Okay? That's in the 73rd Congress, by the way. So if they're foreclosing on you, you got to bar the action until all the parties are properly been notified. So that'd be your Attorney General, your Secretary of State, Secretary of the United States, the Attorney General for the United States. We got to get them down here. They're real parties in interest. They should be listed as defendants. You're trying to foreclose on this property. And I have physical evidence from the 73rd Congress that says the United States has a mortgage on all property, blades of grass, leaves that blow in the street, and every fucking turd flushed down a toilet. So if you're going to foreclose on this property, I know for a damn fact that the Secretary of State and the Attorney General have to be named, as well as the United States of America, as real parties in interest before you can foreclose. A person, creditor, equals international bankers, gives value, approval of a new reorganization plan for extensions of time to pay, for rights to foreclose later as security, promise not to foreclose now, for satisfaction, new payment plan of pre-existing claim, terms of loan agreement equals national debt. Person, United States, gives value, reorganization plan, for rights, defense, as security for partial performance. Person, creditor of U.S., gives value, approval of plan, for rights, foreclose later, as security for, promise not to foreclose. Satisfaction in this subsection can refer to the statutes of the United States created for its creditors to use to more expeditiously collect through forfeiture actions. It can also refer to the United States courts created for its creditors to use to summarily condemn property for confiscation to satisfy the terms of the reorganization plan the United States gave to its creditors, promising performance on a pre-existing claim, national debt. Ladies and gentlemen, your birth certificate is not only a power of attorney, it is also proof that you are a preferred stockholder and creditor of the United States. The following interpretation deals with the United States as the agent and the people as the principal, and with the United States as the trustees and the people as the beneficiaries. B, a person, corporate United States, gives value, certificated security equals birth certificate, for rights to create money on the signature of the man equal borrow from the people, as security, promise not to deny or disparage rights of the people, for satisfaction, acknowledgement of obligation to people of a pre-existing claim, beneficial interest in the trust created by the Constitution. Person, United States, gives value, birth certificate or warehouse receipt, bill of lading, for rights borrowed from people, as security for, 9th article of Bill of Rights. B, a person, officer in the federal government, gives value, Article 6 oath, for rights to hold an office, as security, promise to support this Constitution, for satisfaction, performance of pre-existing claims, people's beneficial interest in the trust created by the Constitution. Person, officer, gives value, Article 6 oath, for rights to hold office, as security for beneficial interest, B, a person, president, gives value, Article 2 oath, for rights to be commander-in-chief as security, promise to preserve, protect, and defend the Constitution for satisfaction, performance of a pre-existing claim, people's beneficial interest in the trust created by the Constitution. Person, president, gives value, Article 2 oath, for rights to hold office as security for beneficial interest. A person, a state, i.e. Ohio, etc., gives value, office in the federal government, for rights to be part of the Union of American States equals Federal United States as security, promise to abide by terms of Constitution for satisfaction, performance on terms of Constitution of a pre-existing claim, promise to pay creditor of the Confederacy. Person, a state, gives value, federal office, for rights to be part of a union as security for payment of national debt. A person, a state, i.e. Ohio, etc., gives value, Constitution, for rights to be recognized internationally as security, promise to pay creditors of the Confederacy for satisfaction, acknowledgement of international law of a pre-existing claim, need for a plan to pay international creditors. Person, a state, gives value, Constitution, for rights recognized as a state, as security for payment of debts. B, a person, state citizen, my mom, my dad, brother, sister, gives value, signature on application for birth certificate. My mom gives value, signature on application for birth certificate, for rights to be beneficiary on the trust as security, promise for satisfaction, distribution from the trust of a pre-existing claim, beneficial interest in the trust created by the Constitution. Person, state citizen, gives value, signature, for rights, beneficial interest, as security for distribution from trust. Now, where it says state citizen, I'm going to go ahead and say American national, because of my research as of late, all right? And, but state citizen just the same with the lowercase s. Subsection C deals with buyers and sellers. Notice that both subsections B and C refer to a pre-existing arrangement. B brings in pre-existing claims that necessarily result from a pre-existing contract. C addresses delivery on a pre-existing contract. On the public side, creditors on the national debt have a seemingly priority position in the commercial code. The only right higher than that of international creditors is that enjoyed by the people in the several states, part of the Union of States. The people have the first and foremost position in equity in the United States as beneficiaries of the trust created by the Constitution and as beneficiaries of the trust created by the President Roosevelt in 1933. The people, through the person they represent in the United States, have priority stock, preferred stock in corporate United States. UCC 1-201, General Definitions 44, value, except as otherwise provided with respect to negotiable instruments and bank collections, sections UCC 3-303, UCC 4-210, and UCC 4-211. A person gives value for rights if he acquires them. C, by accepting delivery pursuant to a pre-existing contract for purchase. C, a buyer, debtor, gives value, promise, or actual payment for rights, receipt equals defense, if he, debtor, acquires the rights, receipt equals defense, by accepting delivery of product on a pre-existing contract for purchase. Now, there's something to point out here. Accepting an acknowledgement of the gift or the creation thereof, okay? Have you accepted and acknowledged the birth certificate, the stock certificates? Have you accepted and acknowledged your birth record? Have you went out there and executed your name decree? Have you changed your U.S. citizen's status? It's not your U.S. citizen status. It's the Social Security juristic person's United States citizenship status with an SS5FS for foreign status. Have you done these things yet? If not, put them on your list. All right. C. A seller creditor gives value, promise, or actual delivery for rights. Receipt equals defense. Your receipt is proof of chain of title. If he, creditor, acquires the rights, receipt equals defense by accepting delivery of promise or actual delivery on a pre-existing contract for purchase. Person, buyer, gives value, delivery of promise or payment for rights, receipt by accepting delivery of product. Person, seller, gives value, delivery of product for rights, receipt by accepting delivery of promise or payment. The terms buyer and seller have a broad scope of application in the commercial code. C. Buyer, U.S. citizen, this is going to be your Social Security juristic person, gives value, pledge for rights, citizenship, if he, U.S. citizen, acquires the rights, citizenship, by accepting delivery of benefits on a pre-existing contract for purchase, application for birth certificate. C. A seller, United States, gives value, citizenship, for rights to use citizen as surety if he, United States, acquires the rights to use U.S. citizen as surety by accepting delivery of pledge on a pre-existing contract for purchase, application for birth certificate. Person, U.S. citizen, gives value, pledge, for rights, citizenship by accepting delivery of the benefits. Person, United States, gives value, citizenship, for rights, citizen to be surety by accepting delivery of the pledge, acknowledging and accepting the birth certificate, and also turning around and making sure to get it authenticated, both state and federal, which under the UCC 9-102, to authenticate is to adopt a record, and it is also to make that record as though it is the original. All right. In a forfeiture case, the defendant can be deemed to be the buyer and the prosecutor can be deemed to be the seller. C. A buyer, defendant, gives value, plea and signature for rights, civil liberty, if he, defendant, acquires the rights, civil liberty by accepting delivery of charges on indictment on a pre-existing contract for purchase, application for citizenship and residency. C. A seller, United States, gives value, civil liberty, for rights to condemn defendant's property if he, United States, acquires the rights to condemn defendant's property by accepting delivery of plea and signature on a pre-existing contract for purchase, application for citizenship and residency. Person, defendant, gives value, plea and signature for rights, civil liberty by accepting delivery of indictment. Person, United States, gives value, civil liberty for rights to condemn property by accepting delivery of plea and signature. In all penal actions for violations of statutes, the national debt is the pre-existing contract for purchase that influences the conscience of the judge in making his decision. In those cases, the defendant is a U.S. citizen who cannot question the national debt. He is deemed to be the surety for the buyer, United States, and he and the prosecutor represents the seller, international lenders. A U.S. citizen who refuses to be a surety can be viewed as giving aid and comfort to enemies of the United States. That is the definition of treason. Once the U.S. citizen is found to be in treason, he can be viewed as a resident. Penal actions are against residents. It is the property of residents that can be seized and condemned and forfeited, confiscated. The book 39 IRS Arguments That Don't Work and Why explains this process in much more detail, it can be found on www.lulu.com. C. A buyer, U.S. citizen, equals surety, equals defendant, gives value, plea, and signature for rights, reimbursement if he, U.S. citizen, acquires the rights, reimbursement by accepting delivery of charges on indictment, equals bill for payment on a pre-existing contract, national debt for purchase loan of credit to the United States. C. A seller, international lenders, gives value, extension of credit to the United States for rights to seize property of the United States if he, international lenders, acquires the rights to seize property of the United States by accepting delivery of plea and signature of surety on a pre-existing contract, national debt for purchase loan of credit to the United States. Person, United States citizen surety, gives value, plea agreement, plea and signature for rights, reimbursement by accepting delivery of indictment. An indictment is a true bill, ladies and gentlemen. And if it's a bill, it can be negotiated, all right? Accepted for value, returned for the same, all that good stuff. Person, international lender, gives value, extension of credit for rights to seize property by accepting delivery of plea and signature of surety. Subsection D deals with anything that is not addressed in A, B, or C. UCC 1-201, General Definitions 44, value except as otherwise provided with respect to negotiable instruments and bank collection, sections UCC 3-303, UCC 4-210, and UCC 4-211. A person gives value for rights if he acquires them. D, generally in return for any consideration sufficient to support a simple contract. D, a debtor, buyer, or creditor seller gives value, any consideration for rights, interest in property, and defense if he acquires rights, interest in property for defense in return for anything of value that constitutes consideration sufficient to support a simple contract requiring performance by one or both parties. Person, any person, gives value, any consideration for rights, interest in property in return for any consideration. The definition of value in UCC 1-20144 does not actually define value. It merely gives example of what circumstances might incorporate value. To recap from the above interpretation, value appears to be or to imply some kind of a promise to provide something or to do something, extension of credit, private man's credit via signature on a note, asset on books, liability on books, pledged to the United States, use of credit payment, new reorganization plan to pay, approval of new reorganization plan for extensions of time to pay, Article 6 oath, Article 2 oath, office in the federal government, constitution, promise, or actual payment, promise, or actual delivery, pledge, citizenship, security, interest in property, civil liberty, plea and signature, extensions of credit, any consideration sufficient to support a simple contract. They are all beneficial to someone or something and are therefore valuable. This list is by no means exhaustive. Constitutional oaths. The foundational agreement behind every commercial and political event in the United States is the Constitution. It is primarily an offer made by the states to those who want to be part of the federal or national governments, and secondarily an offer made by the state to those who want to do business with the federal or national governments. This was a very dangerous document. It created potentially huge commercial machine that had the power to do untold harm to the people. It had to provide a means to pay creditors so the states could be recognized internationally for commercial purposes. At the same time, it had to secure the people's rights, so the commercial machine would not eat the life out of the people. The only offers made back to the people to secure their rights are the two oaths required by the Constitution. These two oaths are the condition put conditions put into the agreement ratified by the states to assure the people who get to benefit from the Constitution by holding office keep their commercial machine away from the people in the several states. One is the oath required in Article 6 of members of the legislature and all executive and judicial officers of the United States and of the several states. Article 6, Section 1, Clause 3, the Senate and representatives before mentioned, and the members of the several state legislators and all executive and judicial officers, both of the United States and of the several states, shall be bound by oath or affirmation to support this Constitution, but no religious test shall be required as a qualification to any office or public trust under the United States. The other is the oath required in Article 2 of the President. Article 2, Section 1, Clause 8, before he enter on the execution of his office, he shall take the following oath or affirmation. I do solemnly swear or affirm that I will faithfully execute the office of President of the United States and will, to the best of my ability, preserve, protect, and defend the Constitution of the United States. There are no Article 6 oaths that can be found for any member of the legislature, state or federal, or executive and judicial officers of the United States or of the several states. They all have United States Code Title 5 3331 oaths, which are for-profit private oaths. The president cannot take the Title V oath of office. He already has another oath to the people. He and others are deemed to be qualified to hold and enjoy any office of honor, trust, or profit under the United States. Notice that only an individual who are elected or appointed to an office of honor or profit in a civil service or uniformed services are required to have the Title V 3331 oath of office, which is private for-profit oath of office, so they can engage in commerce. They do not hold offices of trust. The president does. Only members of the legislature of the state and the United States and executive and judicial officers who are bound by the Article 6 oath can hold office of trust. Those who take the Title V 3331 oath of office can hold office of honor or profit under the United States. An oath is different than an oath of office. Title V USC subsection 3331 oath of office. An individual except the president elected or appointed to an office of honor or profit in the civil service or uniformed services shall take the following oath. I, A.B., do solemnly swear or affirm that I will support and defend the Constitution of the United States against all enemies, foreign and domestic, that I will bear true faith and allegiance to the same, that I take this obligation freely without any mental reservation or purpose of evasion, and that I will well and faithfully discharge the duties of the office on which I am about to enter, so help me God. Judges have the Title V USC subsection 3331 oath of office, as well as another one found in Title 28. Title 28, Section 453 says, each justice or judge of the United States shall take the following oath or affirmation before performing the duties of his office. I, the name, do solemnly swear or affirm that I will administer justice without respect to persons and do equal right to the poor and to the rich, and that I will faithfully and impartially discharge and perform all of the duties incumbent upon me as officer under the Constitution and laws of the United States, so help me God. The only constitutional oath able to be found in the oath is the oath for the president, is the oath the president takes, which is word for word the same as required text in the Constitution. He does not take the oath of office in Title V USC subsection 3331 as long as there is one officer with an oath required by the Constitution, not an oath of office required by the Congress. The people still have a trustee for the trust on which the people are the beneficiaries. The beneficial interest is what gives people the right to A4V, accepted for value, or acceptance for value, instruments that are issued for value. They have an antecedent claim from a pre-existing contract. Their claim is a right to enjoy freedom with liberty. It is based on constitutional guarantees. Since 1933, the people also have a right to a distribution from another trust created by President Franklin Delano Roosevelt. Since 1933, all property is held by the state by virtue of the government. That means the state has the legal title to all substance in the states. But the people have equitable title through their beneficial interest in that trust. Taking control of the gold in 1933 would have been unconstitutional, a Fourth Amendment violation, if the new trust had not been created. The president's oath is an offer to the people in the several states. It might be prudent for the people to accept his oath of office. That's what binds them to it. It is not an oath that is issued for value. It is an oath made in good faith by the man. The principles of offer and acceptance apply to this very critical premise. If the people have not accepted that oath, how can they expect the man who made it to be working for their benefit? As far as he is concerned, it may appear that none of the people want him to be their trustee. Since, well, fuck, that's questionable with old fucking bumbling, stumbling Joe. But anyway, nevertheless, moving on. Since 1933, the only money in circulation in the United States is credit borrowed from the people. The commercial code adopted by every political state of the United States provides for value to be whatever consideration is needed to support a mere simple contract or parole contract or simple parole contract, simple contract agreement. The president's oath is consideration sufficient to support the simple contract the president, executive trustee, has with the people beneficiaries. He does not have an oath of office that is different than an oath. All legislative, executive, and judicial officers performing under him in his capacity as commander-in-chief have oaths of office. He has a constitutional oath. So their dereliction of duty operating underneath him, he carries the primary active degree of default for his agents and agencies' insubordination working underneath of him, all right, which would give the people and grant rise to the people having a lien against his bond and to leverage him for his insubordinates not being properly informed and trained to handle the affairs properly, right? So he carries the primary active degree of fault for all of his subordinates below him. That includes the military, National Guard, state troopers, everybody. They're all fall underneath the United States Corporation, and he's at the helm of the United States Corporation, filling multiple capacities. Value is anything recognized as a pledge or the result of a pledge, including contracts, promissory notes, bills of exchange, bankers' acceptances, trade acceptances, letters of credit. Okay. The birth certificate is the result of the president's oath. Without that one oath, the birth certificate would just be evidence of the obligation every U.S. citizen owes to the United States. Without that one oath, the birth certificate would not be evidence of the obligation the United States owes to the people. On the public side, the birth certificate represents value and is evidence of a pledge by the U.S. citizen to be surety for the United States. On the public side, excuse me, did I read that right? Okay, on the public side, it is security for the pledge of allegiance to the United States and its statutes made by U.S. citizens. On the private side, it is a receipt, a warehouse receipt, a bill of lading, okay? Evidence of a debt, a warehouse receipt, and is evidence of a promise made by the president to the people. On the private side, it is security for the promise of distribution from the trust to the people as beneficiaries. It is a receipt for the use of the baby's physical description that was symbolically delivered by an informant, your mother, to the United States. The set-off resulting from accepting an instrument for value is a distribution from the trust to set off equals distribution. Except when we come back, we'll be going through acceptance.